Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners intrigued by these topics and interested in hearing from the experts in these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Transportation and Energy Industries Committee of the Antitrust Law Section. Today's topic, space antitrust. Mankind has always dreamed of becoming an interplanetary species. The central discontent of human existence has been wanting to know what's on the other side. Whether it was our Egyptian ancestors who adorned tomb walls with what they thought lay on the other side of death, or our Polynesian ancestors who sailed out from their islands without knowing what lay across the ocean, so too have we as a species always looked to the skies and wondered what lies beyond. Space travel has become more of a reality than ever, with technological breakthroughs in the private sector over the past 10 years. Legacy aerospace companies have been joined by well-funded startups, including Elon Musk's SpaceX and Jeff Bezos' Blue Origin, in the race for suborbital and orbital travel. But the road has been uneven. On June 5th, 2024, NASA astronauts Butch Wilmore and Suni Williams rode the Boeing Starliner spacecraft to the International Space Station. But, like the theme song to the show Gilligan's Island, what was supposed to be only an 8-day tour ended up being something far longer. Back in 2014, NASA contracted with both SpaceX and Boeing to develop spacecraft for transporting crews to the International Space Station because, you never want a single source of major government contract. While SpaceX's Crew Dragon vehicle has flown multiple missions successfully, Boeing's Starliner was beset by delays and technical malfunctions, culminating in the 2024 failure. Thruster malfunctions on the approach kept the Starliner docked for 2 months at the ISS while NASA ran a bevy of diagnostic tests. Ultimately, NASA concluded that it was too risky to bring Williams and Wilmore back on the Starliner, and instead plans to bring them back on a rival SpaceX vehicle in March 2025. The whole Starliner debacle got us thinking, can we rely on the free market to preserve competition in space? Is government intervention needed? Or is the race to become an interstellar species winner take all? In the movie Contact, the scientist played by Jodie Foster, trying to describe what she's seeing as she travels through a wormhole, says they should have sent a poet. But for the kinds of questions we'll be untangling in this episode, they'll need to send an antitrust lawyer. Joining me today is my co-host, Amanda Norton, Assistant Vice President and Senior Legal Counsel for Antitrust for AT&T, and also a former co-chair of the Transportation and Energy Industries Committee. Thanks for joining me, Amanda.
Okay, now let me just say, I know podcasts can't win Oscars, but wow, that intro has contender written all over it. Seriously, I'm thrilled to be here to talk about some of the questions that these recent events have raised for us students of antitrust law.
Great. So who are our guests today?
Joining us today are Maria Rhimbassen and Dylan Carson. Maria is a published space jurist with over a decade of professional experience within academia. She has worked as an innovation advisor at HEC Montreal and as a researcher at the University of Toulouse, where she conducted research for space agencies. Maria holds graduate degrees in management, international law, and strategic space law. She's currently based in France. Dylan is an antitrust partner at Manatt, Phelps and Phillips in Washington, D.C., and a former trial attorney at the Antitrust Division of the U.S. Department of Justice, where he tried merger challenges like Aetna Humana, AT&T Time Warner, and Sabre Farelogix.
Yeah, welcome, Dylan, and bonsoir, Maria.
Thank you for having me. So glad to be here. And I have to mention, Contact is one of my favorite movies ever, which inspired me to be in the space sector.
Oh, wow. That's great.
It's actually true.
Yeah, let's go ahead and get right into it. Amanda, the Boeing Starliner debacle, is that a failure of antitrust?
It's a great question, Anant. And I might even add that if it's not a failure of antitrust, is it a feature of antitrust laws and competition as it's manifesting itself in space travel these days? But to answer that question, though, I think that we really need to take a step back and talk about the analytical approach here that we should be using. And to do that, I'm going to go ahead and turn to our experts. Maria, without getting too far ahead of ourselves, we know that at least in the US, there's no specific regulatory framework that governs space travel like there is for some other terrestrial transportation industries, but there are some laws that govern space. So, Maria, can you set the stage for us and walk us through the existing laws that govern space travel?
Sure, Amanda. So I wanted to ask, in the introduction, you specifically focused on antitrust concerning the Starliner debacle. That's actually a question for you guys, but I wanted to clarify that question before I go further into my analysis.
Yeah.
Why do you? Yes.
Oh, your question before you go further is, why did I describe it as a debacle?
As an antitrust debacle.
Oh, that they were trying to create a second company to have competing contracts with, so that they weren't just solely reliant on SpaceX Crew Dragon. But the fact that Boeing is having so many issues as the second company seems like they're not going to be a legitimate competitor for SpaceX for that type of contract.
And to the extent that antitrust law wants to incentivize competition and enable competition in markets, then the failure of a market player and the reliance on a potentially single dominant supplier indicates that perhaps the goals of antitrust law have not been met.
Maria, the question to get you started is, can you walk us through the existing laws that govern space travel?
So the space travel is governed by international space law, such as the Outer Space Treaty from 1967. This treaty is based on broader principles to prevent humanity from going into a nuclear warfare into space, because the treaty was drafted in the 60s during the context of a nuclear warfare fear. So these broad principles within international space law, they're so broad so as to enable international space law to persevere in the long run. That's why it was not very specific, not to be frozen in time. And such principles, they're very interesting in our analysis because they used to be drafted from a perspective of warfare, such as nuclear warfare or weapons of mass destruction. But nowadays, we can take these same principles and interpret them from a commercial warfare, which is the actual tendency if you watch the news. So how do we interpret international space law principles from a trade perspective? And those principles, if I dive into them, you have the first one is peace, peaceful use of outer space, equality, non-discrimination, benefit sharing, cooperation, duty to assist, due regard, non-interference, equitable distribution, freedom of access, and so on and so on. So if you take those principles and take them from an antitrust perspective, then I think there's potential to clash. So if you want to anticipate a future economy with a lot of competition within the market, because there's academic doctrine elaborates on the fact that competition is seen as more and more toxic, and we should move towards a more sustainable and collaborative framework of competition. They call it, and I refer to the progressive school of thought from Oxford by author Ariel Ezrachi and Maurice Tuke. They refer to this new concept of competition as noble competition. So noble competition shifts away from toxic competition. Toxic competition means that the market is in a context of zero-sum approach. And therefore, there has to be one winner and one loser. But from a noble perspective, these two actors, they should work together and even dive into a blue ocean from the blue ocean strategy doctrine, also from the school of thought from INSEAD, a more sustainable ecosystem. Major space players, such as the United States, they came up with a new text, such as the Artemis Accords. You have the Artemis Accords, a new clause that says, you know what, private actors, they're welcome to go on planetary bodies, and the extraction of the resources extracted from their work, well, it belongs to them. And the United States approached several countries who signed the treaty. So now you have a new interpretation that was not rejected by the international community. So therefore, you see that international space law stands, but you have increasingly more and more interpretations that take into account the evolution of today's economy, space economy.
Well, this is great background, Maria. And I think that you've raised a number of questions that we could likely cover in a series of separate podcasts.
Yes.
Here. But as you were talking about the international nature of some of these agreements and the national nature of other approaches to legislating space, it raised a question for me about jurisdiction.
Yes.
Dylan, can you talk us through how we should think about whose laws and which laws apply when we're thinking about space travel? And where does sovereignty end when we're talking about space?
Yes, great questions. First, Amanda, let me say thanks to you and Anant for putting this together so we can boldly go where no antitrust lawyer has gone before. Ad astra antitrust, right? Antitrust to the stars. So fascinating questions. When you think about antitrust in space and, competition, the laws that apply to space travel as a planet are the laws that countries agree to follow when they enter outer space. I think as Maria has laid out, you've got to have planetary bodies, groups of citizens, human beings who live in different parts of the planet, who agree to follow the same rules. And so there's this outer space treaty, which appears to be kind of the Magna Carta of regulating outer space. But there are no explicit competition components to it. There's no antitrust treaty for outer space to govern private competition. So in my quick review of the law of outer space, it appears to be the Wild West of sorts. But Maria did mention there was a non-discrimination principle in the Outer Space Treaty. And that is obviously an important principle in antitrust when players who have market power treat folks differently based on how it benefits them, then that could be a kernel where maybe the green shoots of antitrust could sprout in outer space. I hope that helps, Amanda.
Yeah, thanks, Dylan. And in 5 or 10 years from now, when I see that you're the primary drafter of DMA for the STARS legislation, I won't be surprised because you've clearly given this some good thought. So before we get to the question of whether there's competition in space, we do need to unpack what we mean by space transport and get a little more specific about the possible product markets within that umbrella term, right? Dylan, can you take us through where we should be drawing some of those lines and what might comprise those arguably distinct markets?
So as I look at the many different segments of the space industry, I think about land and places where you can launch from. You need places where you can take off and land. Sometimes they're the same place, sometimes they're not. Whether that's public or private land in Florida, down in New Mexico, or South America, where the last Ariane rocket launched from in French Guiana. So there's a finite number of places where you can take off and land from, which can create kind of barriers to entry for potential companies that want to participate in the space economy. You have rocket building, and there's only a handful of public and private companies, consortiums, and I'm sure Maria knows this much better than I. The resources needed to get into space require massive commitments. And so you've got the SpaceX fleet, like the Falcon, and then the United Launch Alliance, and most recently, I think the other day, actually, here in Japan's H3 launch vehicle brought United States military satellite into space that was manufactured outside of Boston and made its way to a mountain in Japan. So you got a rocket building and the the things that you're trying to get into space. And then I see some vertical foreclosure issues related to kind of the limited number of options for getting into space and kind of the promotion of national champions versus small startups. So, for example, if you have the same company that does the launching is also selling a satellite service that is launched, the payload from the rocket once it gets into orbit, then there may be an incentive to, because of that vertical relationship, to raise the rivals' costs on any other satellite companies that that rely on space launching capabilities to enter the market for satellite services, whether it's satellite internet or weather, or they want to sell satellite services to the military. If there's only a handful of companies that can get that satellite into orbit, then you may have the incentive to prevent competing satellite companies to take advantage or to raise the costs of that launching because of the vertical integration of a launching and satellite services provider. So those are the biggest, I'd say, vertical issues that I can see, but I'm sure there are more.
Thanks, Dylan. Maria, now that we've outlined some of the basics around where one market ends and another begins when it comes to space transport, I do want to try to tie this back to some of the names that our listeners might be more familiar with when it comes to space travel and help them apply the concepts we've been talking about to those names. So when it comes to the big names, do they even compete in the same markets?
Dylan talked about the jurisdiction applicable to space. So in space, what you have is the attribution link. So if you go to Mars, for instance, you can't apply Martian law because that doesn't exist. What applies is the law from the launching site. So if an astronaut is launched from the US and lands on Mars, US law will apply to certain aspects of, for instance, commercial law, criminal law. If you take, for instance, a Canadian on an international space station, what would apply in the Canadian astronaut's case would be Canadian criminal law. Recently, the Criminal Code of Canada added a clause that says anything applicable, like on the International Space Station, is covered by Canadian criminal law. So, and then again, the attribution link is very difficult to define because you'd have the state responsible of the launch, but then what about the country that built the launcher, the nationality of the astronaut? So the attribution link is very, very complicated, and the international legal community is delving into how to make sure of the continuity of this attribution link. If you look now at non-interference, another concept that was mentioned, you have an article in the Outer Space Treaty that talks about non-interfering with the activities of other states. Now, the space lawyers, they meet regularly to try to define what non-interfering with the activities of other states, of other nations in space, what does that entail? Because we have no idea. So there's many working groups trying to bring those definitions into reality. And why I mention this is from a commercial perspective, and more particularly from a competitive perspective, non-interference can be used in competition law as a competitive tactic to try to monopolize a resource, for instance, and preclude other actors from even entering that market. For instance, there used to be a saga between, once again, Starlink and Amazon with Project Kuiper on how to secure orbit rights given certain frequency slots. And so one company would say, I want to apply at the International Telecommunications Union that slot of frequency to secure that orbit and preclude other actors from entering that orbit because their entrance would interfere with my business, with my services, and would be a security issue, a space traffic management issue, etc. So maybe they would even have been able to use competition law instead of more technical regulation or compliance. So just to mention how non-interference can be looked at from a competitive intelligence or business strategy lens, and use antitrust as a tool, or even as a not value proposition, but as a strategic tool to enhance the business model ahead. Because you are mentioning, Amanda, do companies compete on the same market? Well, sometimes they don't necessarily, but to secure a more perennial business model or market, they might innovate on their product, because sometimes the product is not the end of on itself.
So what parallels can we draw between some of the terrestrial transportation markets that are subject to their own regulatory frameworks and space transport?
Yeah, and the idea here, Amanda, is, from the U.S. perspective, are there antitrust frameworks that are analogous that we might want to look to apply to some of the markets we've been talking about? So, for example, railroads, those are naturally occurring monopolies. No one builds competing rail lines. Once you have a railroad line, then you have to heavily regulate who uses it. And so should that be the kind of framework we think about for space cargo market? Or is it more like commercial airlines? There you have multiple entrants operating in deregulated markets, but you can't just take off from anywhere. You have slot constraints because most of these airplanes take off from airports. So should we be thinking about that as an analogous market for commercial space travel and launch sites? Or do we think about it the way we think about the defense industry, where you have diminished competition because it's a heavily consolidated industry that requires huge capital expenditures up front? So you see coopetition between erstwhile competitors and heavy government subsidies to keep competitors in these markets. So panelists, I'd love to hear your thoughts about whether you see any analogies to how we should think about what frameworks to apply to these different markets.
Sure, I could go ahead very quickly and say that you have to keep in mind that although space looks unlimited and vast, anytime you send artificial objects into space, there's a risk of creating space debris. And now with all these mega constellations in outer space, you have increasingly the danger of more and more space debris called Kessler syndrome, that debris will become exponential up to the point, if we don't take care of that Earth would be considered as a prison surrounded by junk. And therefore, to avoid this, there's more and more space traffic management to secure the fact that will not endanger this surrounding space. And therefore, I think that safety is number one in terms of, it's not just commercial incentives, but really sustainability and safety as well.
And I'd add to your point, Anant, that I see regulation and competition law in this area similar to airlines. You've got a vehicle that leaves from one place, is in the airspace over a particular country and travels into airspace over other countries, like current airplanes do. And which rules apply once you've crossed over into, international airspace? And here it's intergalactic airspace, right? So are there agreements on what the rules that apply once you're out above, the particular territory where a flight originated? And for that, I just add that I think it would be beneficial to have some OECD type process for space where, and I understand there's space law conferences where folks debate, if we had some international understandings of how competition law applies to space, where the DOJ and the FTC and the EU and the CMA can submit comments on, international convergence. In the case of space, countries can submit their thoughts on how competition should be regulated and agree to rules of engagement for the commercial players that reside in their respective countries. And then the real big issue that I see is similar to the UN and the World Trade Organization, is how when you get a dispute about anti-competitive conduct that occurs in space, how do you resolve that?
What are some key takeaways here for practitioners? Maria, let's start with you.
Some key takeaways for me would be not to look at antitrust as an end in itself, but as a tool. So to have a broader vision of the broader issue, and then think of antitrust really as an enabling tool.
I tend to agree with Maria. The antitrust laws are kind of general applicability to commercial conduct, and they're flexible, and they apply to competition in lots of different areas. So space shouldn't be any different, whether it's the terrestrial economy to products and services into space, or what actually happens in space when companies, countries, both private citizens and public entities are competing for whether it's a share of moon rocks or resources used to develop some terrestrial economy, or just the people working at the International Space Station. There's a competition law applies everywhere. It's just a matter of how to apply it. It sounds like that Maria and I will be drafting the text of the Digital Markets Act for the stars.
Yes, because that requires a lot of reflection. Yes.
We'll call it the Space Markets Act. I'm sure it will be adopted by no one, but we got to start somewhere.
You never know.
Yeah, but this discussion has been fascinating. So Amanda, Maria, Dylan, thank you so much for this excellent discussion on space antitrust. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.